program may be pre-recorded.
The airing of this program by this station is not an endorsement or recommendation by the station of the products or services discussed in the program. The station does not guarantee the results of any investments made by a listener to this program.
The Word on Wealth with Gary Quackenbush is sponsored by the Word on Wealth Radio Network.
This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary is a San Diego financial solutions attorney, protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. Now, here's Gary.
You're live.
Happy Monday, everybody. Welcome to the Word on Wealth. Very glad to have you along. For those of you that are listening, this is a good show. I'm glad you're here. We have lined up at about the half hour. We've got Rich Mathurin from GQ Law. He is the tax legal attorney that deals with tax situations, money situations. Great guy. He's been our regular guest on this show as one of the associate attorneys at GQ Law. We're grateful to have him here, and that's going to be coming up in a little bit. Now, I want to make sure that you have the opportunity to ask me questions that you are curious about regarding estate planning. So for the first little bit, we're going to be talking about some specifics of estate planning. And I'd love to hear your questions so that I can guide, I just want to be able to tell you what you want to hear. I don't want to just be repetitive. A lot of this stuff is repetitive, but it just takes a while to kind of get to the topic that you like. And if you want to hear your topic, ask me a question. You got me cornered here. You got me and Rich, the second half of the show. The number is 888-344-1170. It's 888-344-1170. Call now. We've got lines open, waiting for you to have your questions answered right here live on the air. We won't do anything that is horribly embarrassing at all. I mean, the whole idea is that to give you the opportunity where you can come and chat with us about what your estate planning stuff is. Now, here's a couple of things that have come up. This comes up quite a bit. I know that's something that I say a lot, as I say, oh, this comes up all the time. But I guess part of it, because when I do this for, 33, 34 years, it does come up, and maybe I have a good memory and I go, wow, this happens all the time. But so the situation here is where you have mom and dad. Your dad has a business, and in this case, let's use an example of a repair, like a car repair place. Okay, so car repair. Dad's been working on this business for like 30 years. They do car restorations. They do car repairs. They can do tires. They can do everything in general. It's more like a mom and pop. The mechanic is the owner. Has got grease under his fingernails. That's the best kind of mechanic you want. Guy knows everything about it. He has employees. He watches over them. His wife comes in and helps with the books and helps with the stuff that's going on day to day in the office, but it's really not her thing. She's really an affordable helper around the shop, it happens. Okay. Well, what happens is dad passes away. Now there's a crazy thing. Like, what are we going to do? Dad's dead. Mom knows how to run the business from the money standpoint, but she doesn't know how to, what to do. She doesn't understand the mechanics part of it. She's not supposed to. That wasn't her job. Now, what is she going to do? Well, in this scenario, dad and mom were smart, and they have a living trust. They set up the living trust. They transferred their family business into the living trust. Now, that can be done in a number of different ways, but for our discussion, it was in the living trust. What that does is it gives the trustee or the successor trustee the authority to operate the business, because the successor trustee is technically the owner. So in this case, mom and dad create the trust. They are the trustees. Okay, they're co-trustees. The documents say that they can function independent of each other. So they are independently functioning co-trustees. They don't have to make decisions together. They're independent. Dad passes away. Mom is now the sole trustee. That means mom has all the legal authority as an owner of the company. And this works if it's a sole proprietor. It works even better if it's a corporation or an LLC. So mom now has the ability to use the business license, operate the corporation, take money, make payments, all that kind of stuff. And she can go hire somebody else. So instead of just like bailing on the company and running away and letting it just fall apart, which is one way to do it, she would lose all the value and she'd have some issues with, the lease and all that kind of stuff on the shop. And she doesn't want to do that. But she doesn't want to run the business. She wants her kids to do it. How do we make that transfer? Mom's alive. Now, if this is something that it sounds familiar or something you want to talk about, I'd be happy to give you an initial consultation at no charge. It's 855-500-TRUST. And we can talk about it, about your specific situation. Now, mom has options. She could give a power of attorney to her oldest son because he's the one that's interested. In fact, he works in the shop. So that's super convenient. Not always the case, but so she could give him power of attorney, which would let him then be able to do whatever in the business as power of attorney because she's the trustee. She's technically the owner. If she gives him power of attorney, then he can pay the bills and take in the money and do all that. And that's one way to do it. It's not the best way to do it, but it's a possibility. Okay. The other way, remember, she's the trustee. She could resign as trustee. So she signs a document that says, I am the trustee. I don't want to do it anymore. I'm ready to resign in favor of my first named successor trustee. We look in the trust document and it says Sam's son. Okay. So their first son, Sam, is named in the document in the trust as the first successor trustee. So mom resigns and she signs the document and we actually have Sam sign it as the successor trustee, the one taking over. And what have we just done? The trust owns the corporation, owns the shop. We just transferred the trusteeship to the son. Okay. Does that mean the son owns the shop? No, it's still in the trust. It's still controlled by the trust. This trustee now has the obligation to manage and run and everything and do it for the benefit of the beneficiaries of this trust. Who is the beneficiary? Mom. Right. So son runs it as the trustee, the successor trustee of that trust. The beneficiary is mom. That means all the net profits and everything are going to go to mom as the beneficiary of that trust. Of course, the son can be paid. He can be paid more now because he's the manager. He can be paid everything. Depends on what mom decides as the beneficiary. But he now has control through that living trust, which is super awesome. If mom became incapacitated, he, as the successor trustee, can still manage the property. If he has a power of attorney, he can manage even the property that's not in the trust. Okay. What is the big difference between the two? Between just giving him a power of attorney, so no trust, give him a power of attorney, let him run the business, or put it into trust and have him be the successor trustee. What is the difference between the two? The difference is, as a power of attorney, it's an unlimited power of attorney. So he can do whatever he feels is necessary to run the business. And if he wanted to, he could sell the business. He could take all the money and give it to a charity or whatever. I mean, not that he would. His mom would probably beat him up, but mom might be incapacitated. Who knows? She can't do anything about it. But the power of attorney can do whatever they want to do. They have power of attorney, 100% authority, 100% trust, full faith, and whatever. Power of attorney can do whatever they want. Now, there is some responsibility there. They can't totally go crazy, but I've seen power of attorneys go totally crazy, take over businesses, take over homes, whatever. I don't like that idea. What is the big difference? Okay. In the scenario that I like, he is the successor trustee. What is the big difference between a successor trustee and a power of attorney? I'm going to tell you that coming up next, right here on The Word on Wealth. If you want a consultation with me, it's 855-500-TRUST. And coming up next, we're going to open lines 888-344-1170 here on The Word on Wealth.
You don't need to know everything. You just need to know where to find
You're doing the show tomorrow from your office, right? For AK?
Wealth with Gary Quackenbush. The Word on Wealth with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQLaw.com.
You're live.
Happy Monday, everybody. Gary Quackenbush here on the Word on Wealth. We're in the middle of talking about the difference between a successor trustee handling a business and somebody with a power of attorney handling the business. So I want to go back and tell a couple stories about that. One, we had I've told this story before, but I just think it's funny. A lot of times you see somebody gets an estate plan and they want a general durable power of attorney. That means general means covers everything. Durable, which it needs to be, because if you're incapacitated, you want it to still work so your agent can help you when you're incapacitated or incompetent. And then power of attorney, you're just turning over the authority to this person based on the document. Well, the document doesn't say the trustee can only do this and only do this and only do this, and everything they do has to be for the benefit of this particular person. It doesn't say that. The power of attorney says this person can act as if they were the person giving the power of attorney. So it's a very powerful document. If you're, I had one where a client came in and he says, I want a limited power of attorney, and I want it so that the only thing that my wife can do is complete the refinance of our property, and it's only going to last for 6 months. That's all she can do. Refinance property is going to last for 6 months. I said, okay, that's really specific. What's going on? And he was telling me about he and his wife were in the middle of refinancing the property during a time when refinancing was a complete nightmare. So it was a lot of work. And he started the process and was going on a across the country, which would be about 6 weeks there and back, cross the country motorcycle ride with his buddies. And he wanted his wife to be able to finish the refinance while he was gone. And so it was pretty obvious to me, like, oh, I get it. Because if he gave her, hey, hon, I trust you, here's my general durable power of attorney, possibility, apparently she's a little bit hesitant to, like, kind of, not that she'd had to agree to it, but she's a little annoyed that he was like going and not, he's taking all the vacation time for the year to be with his buddies, not with her, which would be annoying. I understand that. So he wanted it so that all she could do is the refinance, not sell the home and move to another state without telling him. So power of attorneys have their place and limited ones have a very specific place. Okay. So the difference with a successor trustee then, because in our story, mom is helping dad run his automotive business, which is robust and did all kinds of great things for people. He passes away. She's now the one running the family business, and it's really his business with her helping. So she's trying to get to where she doesn't have to run the business because she's not a mechanic. So she can give her oldest son power of attorney because he works there, and that would be great. Or she could resign as as trustee of her trust. She resigns, so now she's no longer the trustee, but it would be in favor of her eldest son, who's now the successor trustee. And now he can function and act as the operator, owner of that business because it is owned by the trust, which he now is the successor trustee over. Okay, difference between the two. A trustee is a fiduciary, okay? And the duty of a fiduciary is that they have to act in the best interest of the beneficiaries. They have to act in a way that preserves the trust corpus for the beneficiary. Trust corpus is all the stuff, the money and property that's sitting in the trust. So they have an obligation under California law to function and preserve the corpus of that trust. In this case, it would be the business and the money and all that, the stuff that's in the trust. He has a fiduciary obligation. Fiduciary is a big deal because if he breaches that duty, doesn't do what he's supposed to, he can be held responsible with fines and penalties. And if it gets too bad, it goes way beyond that. Okay. But as a fiduciary, he is legally obligated to act in the best interest of who? His mother, because she is the only beneficiary at the time. She's alive. She may or may not be competent or she may or may not have capacity. But that doesn't matter if she's competent or incompetent because he is the successor trustee and she is the beneficiary. All right. That's the big difference. So Gary, why do you like to use successor trustee positions rather than power of attorney? Because power of attorneys, if I were going to write a book, and I actually started one, I never finished it. That's okay. It's just kind of my thoughts and ideas. the craziest stories I could tell are regarding power of attorneys and regarding guardians, like failure to designate a guardian. So those are kind of my two crazy story areas that I have over my practice, is that, you know, that it's the bad power of attorney that ruins everything. The bad trustee, you can sue a trustee, you can get the court to supervise things, you can require them to do an accounting. You know, they can't really, if you walk into the bank with a, you know, if you're the successor trustee, like in the case we're talking about with the business, if that guy walks into the bank and says, you know, I want to withdraw all the money out of this bank account, I want a check made payable to me personally, the bank's never going to do it. In fact, the bank's probably not going to do what they're asking, because they're going to say, wait a minute, this is money in a trust. Who's the beneficiary? Let's get your mom in here. Let's talk to her. But if he went in and had a power of attorney and it was properly signed and notarized and all that, he would go in and say, here's my power of attorney. It's authorized. In fact, I have the original here. He doesn't need the original, but I have the document here, and it says I have the authority to drain this bank account, and I want the bank account. They would write him a check. You know, that's the difference between the two. That this power of attorney doesn't have instructions on what they're supposed to do with the money. It just gives them authority to do whatever. But the trust gives them specific instructions on who is to benefit from the transaction. So I like trusts. I really do, in case you couldn't tell. When I do an estate plan, I'm generally doing a limited durable power of attorney, so that, you know, the one I like the best is regarding financial accounts. And it says it's a limited durable power of attorney, and that the person that's assigned has the authority to transfer checking, savings, CDs, any deposit accounts, any monies held in banks and institutions, that power of attorney has the authority to transfer that money to the living trust. That's all they can do. So they can't use that power of attorney. They can't go to the bank and say, okay, give me all this money, because the power of attorney doesn't say that. The power of attorney says you have the authority to transfer that money to the trust. So that means the bank person would have to write the check or the money order, the cashier's check or whatever, and have to make it payable to the successor trustee of the such and such a trust, because that's what the power of attorney says they have to do. So they're super cool. I mean, that's why I like limited durables. And there are sometimes when I'll use a general durable power of attorney, but I really want to know the purpose, so I don't have to like go too crazy and put in, 12 pages of, they can do anything they want. I just, want to make sure the relationship is there between the person getting the power of attorney and the person needing the power of attorney to be given. Okay, awesome. Questions on that? Call me 855-500-TRUST. 855-500-TRUST. Get your free consultation. I'll review your trust. I'll review your estate plan. I'll talk to you about an estate plan and power of attorneys and the things that you need. The next thing would be, if you want to call this show, I'd really love, we got Rich coming up in a few minutes, Rich Mathurin from GQ Law, to talks about tax situations, and it's tax time. So we're not talking about actually tax preparation, but tax situations that might be some trouble. We're going to be talking about that coming up in a few minutes at the bottom of the hour with Rich Mathurin. If you want to be part of the show, if you want to ask me a question, the number is 888-344-1170. And we do have the lines open right now. You can call 888-344-1170. Conservatorships. Now that we're talking about power of attorneys, unfortunately, it's time to talk about conservatorships and what that does. When do you need a conservatorship? My short answer is you need a conservatorship when things are not done properly, because we, with the trusts that we set up, with the limited durable power of attorneys to transfer assets to the trust, with trying to make sure property is properly put into the trust, if it's done right, you avoid a conservatorship. You just use a healthcare power of attorney that lets somebody take care of your health needs and your health decisions. And the conservatorship, you really only need it if you don't have a good healthcare power of attorney. The other thing with a conservatorship is, like, there's two types of conservatorship. One is going to be the conservator of the person. The other is the conservator of the estate. So person meaning medical decisions, where to live, who to be with, anything to do with your person and your physical care and needs and necessities and all that. And then the other type of conservatorship is financial. It's called conservatorship of the estate. And it is anything to do with the money, the bank accounts, the car, any assets. Wow, I was in the desert over the weekend. I guess I got dried out. Then Okay, so if you have a power of attorney, a limited durable power of attorney to transfer assets to the trust, you're probably not going to need a conservatorship ever. We ran into one very recently where the husband, in fact, we ran into a couple where the person that did the trust, the person that put the person that put the trust together, that got the trust, they never went and transferred their big money accounts or investment accounts into the trust. So there's no beneficiary designation on the investment account, which is a big mistake. There's no transfer on death or pay on death designation. And the account was just in the decedent's name. So what happened is even, if the person's not married, it's going to go through probate to follow the will. And the will says, put everything in the trust. It's a pour over will. So we're having to take the pour over will to probate to transfer financial assets to the trust. If the financial assets were properly funded or put in the trust, retitled so that they're in the name of the trust, or if somebody had opened the new account and did the proper transfer, we wouldn't be doing a probate. Okay, now what about the situation where you have
2 minutes.
With the probate? The other thing was, what about a spousal situation? So you have wife has an investment account with, I don't know, $300,000 in it, and it's just in her name. There's no beneficiary designation because, it's been years and years and years and somebody forgot to ask, or the beneficiary that she has is deceased. So that means the default is it goes to her estate. So it just goes into her own personal estate. Now she's married, so she passes away. And what is the rule with that money? You would think it would all go to the spouse, right? But it's her separate property. If it's her separate property, it's going to go to her kids if she has any. If she has one kid, it's going to split half to the husband and half to the kids. If she's got more than one child, then it's going to go 1/3 to husband and 2/3 to children.
About a minute.
And you've got the different situation where if she doesn't have any children, then it's not all going to go to the surviving spouse. So separate property does not go to the surviving spouse. And a lot of people think it does because, well, there's no kids. Obviously, it's not going to go to her children. It's going to go to her spouse. And that's actually not true. It just shows the real need to make sure that your property is put into your trust. It's in there properly. It's properly funded, the title. And if you look at your investment account, and you open it up and it doesn't say family trust or reference your name and a trust or trustee, if it doesn't say anything like that, then there's no way it's in the trust. So you would contact your financial advisor guy and say, hey, what happened? What happened was supposed to be in the trust. Can you help me do that? Okay. Funding is super important. It keeps you out of conservatorship. If you have a healthcare power of attorney and your trust is properly funded, you're not going to need a conservatorship. That's just the way it works. Thanks for being along with the Word on Wealth. Coming up next, we got Rich Mathurin of GQ Law talking about tax situations right here on the Word on Wealth.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning.
Hey, I had emailed Craig today about doing our taxes since he kind of
consultation or to talk with a member of the GQ team. That's gqlaw.com. 855-500.
You're live.
Hey, welcome to the Word on Wealth. Let's get you over this way. All right, we got, as promised, we got Rich Mathurin of GQ Law on with us now. It's tax season. Totally good reason to have Rich on to talk to us about tax situation. Now, we're not taking questions specifically about, what can I take a homeowner's deduction or anything like that? We want to talk about situations where if you have an issue with a tax problem, that's what we deal with, like tax problem solving. And I'll let Rich kind of get into that a little bit with you. How you doing, Rich?
Great, Gary. Good to be here.
Good to have you on again. We just appreciate you being a regular guest on the show. It always works out nicely. But at least we have somebody around here that knows what they're doing from a legal standpoint. All right. Now, so so as far as like this year, because of why did they extend the tax deadline?
Because of the flooding in California. So the
Oh,
IRS
that's right.
and the Franchise Tax Board have extended it out a month. You have an additional month to file just because of the flooding and the impact it had on Californians. But
That's
I
right.
I
That's
wouldn't
right.
wait.
Yeah, I mean, that's the thing. Like our guy Craig, he's still doing the same thing. He sent out his organizers at the beginning of the year. He's still pushing people. Yeah, because if you wait, you're gonna go past it again. It's just not worth waiting. And the other thing about you guys with the tax filing deadline, I mean, that's when the taxes are due. And if you don't file on time, let's say you go and you decide you want to get an extension because even May is too soon for you. Well, if you get an extension and then you have to pay taxes, like you get your return calculated and you go all the way to the October extension and then you file. Well, the extension is for time to file. It is not time to, it's not an extension of time to pay. So if you haven't paid the taxes and you get a calculation back in October that now you owe $5,000 in taxes on your return, you're going to pay interest and penalties on that money back to April 15th. So it's not an extension of time to pay. It's an extension of time to file. That's it.
Yeah, and I would I have seen that the IRS has had a lot of difficulty in processing paper returns. So this might be a good year to engage. If you don't already have a tax prepared, engage that person and have them file your file electronically, especially if you're expecting a refund.
Yeah, I mean, it makes sense. I mean, and I know coming from, two attorneys that, of course, we're going to advocate for not doing it yourself. I mean, some people can if it's a super simple tax return. The thing I've always appreciated about hiring a professional is, because I mean, obviously I can do it myself. I'm a tax attorney. Rich could do his own too. We know how to do it. But the nice thing about having somebody do it for me is that I don't have to worry about whether I missed some of these insane tax law changes. I mean, we go to these tax education
Nick from El Cajon
classes and we go to these tax education updates and there's literally I think this last time was a 450-page book with all the changes because they change and change and change. And especially if you're self-employed, there's just so many changes with dependents and how do you report the monies you got from California and from unemployment and all that. And that's the stuff you don't really, if you're calculating it, you might get it right. Your software might get it right, or it may not. And then you're going to get a letter from the state of California or the IRS, and it's going to be next year or the year after saying, hey, you messed up and you should have done it right and you didn't. And so now you owe penalties. And so not a good thing. All right. So we're going to take a call. We have a gentleman from El Cajon. Hi, this is Gary Quackenbush. Welcome to the Word on Wealth.
Hi. Okay, I'll jump right in.
And then give me your name again. What was your name?
Okay, my name is Nick.
Nick. All right, Nick from El Cajon.
Yeah.
You're on with Gary and Rich. What can we help you with?
Okay, I have a client. I'm a real estate agent, and she purchased a house 40 years ago for $20,000. In 2019, she moved out of that house and started renting it, and now she lives with her boyfriend or whatever it is. Now she wants to buy his place. They told me he's probably going to pass away within a year. When he does, she wants to sell her old place, use that money to buy the place she's living in now. And so I told her I didn't know about the taxes, how that worked. And so I'm calling you guys. Maybe you guys would help me out.
Okay, so so the guy bought the house that you're trying to sell. He bought it 40 years ago. And now
She
he's
did.
not living there anymore. It's a rental now.
No, okay. So, I mean, she bought a place 40 years ago for 20 grand. Then she moved out in 2019.
Okay.
She moved in with her boyfriend. Her boyfriend's going to pass away. He's
Okay.
like 85 years old. So what he does, he wants to sell her the place they're living in currently.
Which is
Because that,
which is his home.
Yes.
Okay. So her home has now been rented out for 4 years, and they moved into his home, and she wants to sell his home.
No, she wants to sell her house to pay for that.
Her house that now is a
She's
rental.
Yeah.
Okay.
She wants to sell that to purchase the place where she's living now because he's going to sell it to her.
Okay.
Does that make sense?
Yeah, she lived in a house for 40 years. Now it's rented out for the last 4 years or so. She wants to sell that house, and she can use the money for whatever she wants to use it for. Yeah. And so what's your question on that?
Okay. So are there taxes on that, like a capital gains tax?
Yes.
Because she doesn't live there anymore.
Yes.
And that's even if she's buying another house, that doesn't matter anymore because it's a rental.
Doesn't matter. Yeah, it doesn't matter.
Yeah,
it's a rental.
right.
She has to live there. It has to be her primary residence. She has to live there for 2 of the past 5 years. So if she's been out for 4, that's too late. If she was out for 3 or less, then it'd be close. But yeah, once she's been out for 3 years, then now it's just it's a rental. So the capital gains, if she sells the property, she's gonna have capital gains tax, no exclusion based on her income tax rate. So capital gains are still low. I mean, the current administration hasn't messed that up yet. They're still pretty low depending on her regular taxable income.
Was it like, yeah, she's retired, so they like 22% or something like that?
Well, it's either going to be 0, 10, 15, or 25, depending on her tax bracket. So that's something probably for her to look at. But yeah, the only way for her to get out from under paying capital gains, part of capital gains taxes, if she moved back in for 2 years, and then she would get a $250,000 exclusion. So she's still going to have gain. she's going to get $250,000 of credit.
And she did a remodel on the place for $70,000. Does that matter anything at all? Does that help her out with anything?
Yeah, that increases she gets credit for that when she sells it, as far as like that would reduce the amount of taxable income of the property. Yeah.
Increase our basis. Yeah.
Yeah, it would increase the basis.
And then does a state capital gains as well, or I'm assuming?
So the answer is yes, the state has capital gains, but there's no special capital gains tax rate. The capital gains taxes in California is just the ordinary income tax rate. So it could be, it's up to 12.5%. That's the max. So it could be, 3 or 4, it could be all the way up to 12.5%.
Okay, that's what I kind of suspected.
Yeah, but it's not like she can roll it over into this new house. It's not a 1031 exchange. I mean, she wants to buy his house. They're living in it, right?
Right. Yeah.
Yeah. So it's not a rental. So they can't do a 1031 exchange, a like kind exchange, because it's not like kind property. It's rental property.
Yeah, it gets more complicated. It gets more complicated than that because the house he has is a mobile home that's on a land lease, so it wouldn't work either way for that. It gets complicated. I left that out because
that's fine. And that's the thing. It's one of these things where you go, wow, you for 40,000, and now you're going to sell it for what, 400,000 or 500,000, and you're going to have to pay taxes on it. It's kind of like you shrug your shoulders and go, wow, we made a heck of a lot of money on that thing anyway. So hopefully that answers your question.
Okay,
all right, Nick from San Diego. Thanks for calling us up on that. If you have any other questions, anybody, we got lines open at 888-344-1170. You can talk to me or you talk to Rich. Sorry, Rich, I stole that one from you.
No, all you.
All right. So we're talking about tax situations. If you've got something we can help you with, call us at 888-344-1170. You're on the Word on Wealth, listening to Gary Quackenbush and Rich Mathurin. You got 2 lawyers on the line today, man. You got 2 lawyers. You might as well give us a call, 888-344-1170. We're going to be talking about coming up next with Rich is, what if you don't file your tax return? I mean, is that a problem? I mean, how long can I hide, Rich? We're going to be talking about that. We're not going to tell you how to hide. Just want to tell you what's coming up on this. You're listening to the Word on Wealth. If you want a consultation with either me or Rich. The number is 855-500-TRUST. That's 855-500-TRUST. All right, get your phones ready to dial 888-344-1170 when we come back in a moment.
This broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST, gqlaw.com.
You're live.
Welcome to Word on Wealth, friends. So good to have you along. Today is our special Monday edition where we have Rich Mathurin from GQ Law. Rich is an attorney. He's been an attorney for a long time. So have I. So you got a lot of experience here on this radio show. If you want to be part of the show, ask us a question. Now's your time. Not going to wait much longer. 888-344-1170. 888-344-1170. Call and you can ask a question. We'll be happy to answer it. Rich, the tax deadline now, when is it? When do we have to file this year?
I think they give an additional month. I want to say May 17th, maybe, but probably May 15th at the earliest.
Yeah, let's see. What was the calendar? I never can remember because
Yeah,
it's like,
it
oh,
falls
it's April
on it.
15th and then it's the 16th, then it's the 17th. So if we went to May, we're just going to bring up our little calendar here and see. May 15th is a Monday.
Okay,
And
but I think,
I know they always move it out for some stupid
but it
thing.
was
like,
April, I think was on a weekend or something like that. So it may be a month after whatever the April deadline was.
yeah, so we know it's going to be at least the Mother's Day. No, 15th would be Monday. So yeah, it's going to be, who knows what's going to be. Get your tax. Yeah, it's a 30-day extension. April 15th was on a April 15th was what was it? Oh, it was Saturday. So then Sunday. So the the taxes were due April 17th. You're right. Gosh, Rich, I love it when you're right. So yeah, you're right, May 17th. But get your stuff done. Don't string out your professional. Get your returns done. Get them on time. Get them done. I mean, wouldn't you believe? I mean, Rich, if you're gonna owe taxes, isn't it better to just kind of get your return ready, figure out what you owe, and then kind of make a plan? I mean, so that's my first question. The second is, so if I file a tax return late, because I don't know, it's been 2 or 3 years, I'm kind of scared because I didn't file the first year and now I didn't do the second. Now I'm like terrified. When I electronically file my tax return, is it like instantaneously they're going to go snatch my bank account?
No, I think it would, take them a number of months to do, process your return and try to, if you were something they wanted to review, it would take them a number of months. Like I said, the IRS is
Alan
on a slow pace of processing returns and back tax returns. But I would suggest getting them filed. That's the worst suggestion. If people say just keep not filing and hope that the IRS never catches up with you, they will catch up. And when they do, they're going to assess interest and penalties. And what I think we've talked about this before, you want to avoid the substitute for return. That's where they get information about your income, W-2, 1099, and they file their own return for you, and they give you the standard deduction, and then they tax you at the highest rate. So those balances are often much higher than if you had to tax prepare, do your own return and file it. Also, those balances are never dischargeable in a bankruptcy. And the thing I want to make clear is if you file and you accrue balances, there are plenty of solutions, whether it's a payment plan, an offer in compromise, possibly a bankruptcy. So there's a bunch of solutions. Don't think that just because you file and you owe taxes that you're totally not gonna be able to live your life. They want you to file, get in compliance, and then they will work with you to get in on a payment plan or settle your balance, with an offer or whatever. But you do need to deal with it. What they hate the most is people don't file, and they have to start chasing you.
Yeah, and I think the thing is, if you do file, I mean, there are options, there are solutions, and that's really kind of the drum that we're beating, is like there are solutions, there are options, and it's not like you file the return electronically and then they immediately go and suck all the money out of your bank account. They have to go through the process of processing the return, like Rich is saying, and even if they send you a bill saying you owe this money, pay it immediately, they still have 3 more months of notices that they have to send out. So it's like just deal with it, just get it together, and let's figure out a plan. If you wait till the last minute, your options are just like, they're crazy.
I also will say, if you've lost your job or you don't have the income to pay, they do have what they call a non-collectible status for the IRS or a hardship status for the California Franchise Tax Board. So that they would give you time to either, if you didn't have money now and you continue to not in the future, they're not going to collect against you, get in this non-collectible status. But, if your circumstances do change in the future and you get a job and you do have ability to pay, then they're going to take you out of the non-collectible status. But they do understand if you've lost your job or, have some type of medical emergency or whatever, they will work with you. But you do need to, come clean, file your returns, find your balances and deal with them. But there are solutions.
So you're saying the IRS does have a heart?
Well, I mean, I think the thing that everybody thinks there's a special deal for, Joe Smith out there that, they have their programs and you have to fit into those programs, but, there isn't any special deal, but there are programs that work with you, whether it's an installment agreement, possibly an offer. We've talked about that in the past. Maybe you do need a bankruptcy. Maybe you need a fresh start, or maybe the non-collectible is the best thing for you there. That's four just right off the top of my head that it's going to probably hurt a little bit, but at least getting it dealt with and not getting it off your mind. So you don't fear them coming, when you least expect it. That's the best thing to do. Deal with it now.
And I agree. That's the worst thing is, say that again.
Have a caller.
Oh, what's his name?
Alan Chulavista.
Alan Chulavista. This is Gary and Richard. Welcome to the Word on Wealth. How can we help you?
Hi, Gary. You guys are interesting to listen to, whether you have calls or not.
Thanks.
Hey, I think I read someplace that those extensions may only apply to people that are affected by the flood. I know that makes it kind of complicated, but that's the government process becomes more complicated as you go along anyway. But
right,
that you maybe have to qualify for extended by putting you in a flood zone or something like that.
Yeah, there's basically they have declared disaster zones in different counties in California, and it's like most of the counties. I think Imperial County might not apply, but San Diego County did, which surprised me. I mean, you can actually look it up. You're right. It's when I looked at the chart, it was like almost every county in San Diego, in California qualifies, because it's all the way from, Shasta County down through LA, but yeah, it's true. Look it up. Make sure you've got the right county. But for the most part, it's like, I'm surprised it was San Diego. I mean, wow, we had some rain, so we should call it a disaster, but that's kind of, I don't know why they do that, but they did. But that's a good point. Look it up. Make sure you're in the right zone, because you do have to claim I filed late because I'm in the disaster zone in San Diego County.
Okay. I had one more question.
Sure.
My wife and I are in good financial condition, so it doesn't apply to us. But what about people who have problems? How do they know who to go to? Like if you go to one of these large corporations that I won't name, and you walk in, you're not getting the top level of tax preparation. I don't feel we go to a lady that's an enrolled agent, and she's been doing our taxes for years, and we're happy with the results we get from her. But how about the person that just doesn't know where to go to get their taxes done, or they're doing them themselves?
Again, I would suggest, if you have a simple tax return, you're a wage earner and you're going to take the standard deduction, like Gary said, you probably can do it yourself or go to a H&R Block or TurboTax. But if you have anything more complicated, you have your own business, you have retirement distributions, you're going to have, your own deductions. I would suggest going to at least a tax preparer or an enrolled agent. An enrolled agent is a step up. The person, is qualified by the IRS and has more experience and has more. They do more courses to maintain that status. So I would suggest, if you're complicated at all, make sure that you go to somebody that can help you. I think it's worth the extra, penny wise and pound foolish, I suppose.
Yeah, and sometimes it's surprising. It's not that. It's really not even more expensive. But it's like anything. I think Rich agrees with me. Is like you got to shop for somebody that you want. I mean, at GQ Law, we have a tax professional that does most of our clients' returns too.
2 minutes.
But there are a lot of people around that do taxes, and you interview them. How many? This is a back tax return. I haven't filed in 3 years. What do you suggest? What can I help? But you could always call GQ Law and we can refer you to a tax professional. Or if you have a tax situation, that's what we'd expect. Call us at 855-500-TRUST and we can help out. So, hey, Alan, thanks for your questions. That makes it exciting.
That was a great answer. Thank you.
Appreciate it. All right. Thank you, Alan. Thank you, Nick, for being part of the show today. That was really great. Appreciate you guys calling in. So for the last little bit, we've got just kind of a wrap up. Rich, file tax returns or not?
Oh, most definitely. Please do not. That's my worst nightmare is people coming in and they have 10, 15 years of missing tax returns, and then we have to recreate Humpty Dumpty. So please do file them. And there are solutions. I promise you, we can work with you. Installment agreement, possibly offer compromise, possibly a bankruptcy, or possibly a non-collectible status. Those are all options that might be open to you. And one thing when you call in the free consultation, I will tell you which program is best for you. You know, I'm not going to say file an offer. It'll definitely go through. You know, we need to do an analysis and find out exactly what taxes, how much you owe and what your income and assets are, and see if you qualify for an offer, see if you qualify for non-collectible, see if you qualify for a bankruptcy. But there are options, but the first step is to file your tax returns and deal with it.
Yeah, exactly. And that's the thing with options. I heard an adage, and I always thought it was funny that that when you stick your head in the sand, your rear end is still in the air and the lion is still charging. So don't do that. Don't stick your head in the sand. And if you have, that's okay. We can help you out with that as well. We have this crazy cool report that Rich is able to get.
Tell a friend about the Word on Wealth, featured since 1995.
Whoa, somebody changed the clock on me there without telling me. That's